Hello and welcome to this video on intoxication. Intoxication is one of the 5 general defences in the AQA specification, and it's a capacity defence along with insanity and automatism, and is accordingly related to mens rea. The other 2 defences, self-defence and duress, are necessity defences where the defendant is absolved of liability as it was necessary to act as they did. So although they did commit both the AR and MR, they are saying that it was necessary. So it could be examined anywhere in paper 1, from a multiple choice question to a defence in a 30-mark scenario. And it's strongly linked to public policy, as there are clear reasons why we might want to limit the use of intoxication as a defence, particularly as it's estimated that half of all violent crimes involve a defendant who was intoxicated. And it has a strong link to fault, which is also examined in paper 1, because we want to punish people who are at fault, and the law considers becoming intoxicated to be blameworthy. So we're going to start by looking at the structure, and you'll usually have considered an offence first. But in the shorter questions, you just need to read the question carefully, because it's probably going to give you a focus if it's a 5 or 10 mark question, whereas you will probably need to consider a whole offence and then a defence if it's part of a 30-mark scenario. So starting by defining the defence as being under the influence of drink or drugs or another intoxicating substance, for example, glue. And then there are these 3 elements. Firstly, can the defendant form the necessary mens rea? Drunken intent is still intent, which we'll look at in a moment. Is the intoxication voluntary or involuntary? And we'll look at the difference. And is the offence specific or basic intent? And the effect of the defence depends on how you answer those questions, and is the key to getting good marks in intoxication. So we're going to start by looking at the first element we identified there, which is forming the mens rea. If a defendant can still form the mens rea of a crime, then they can't use the defence of intoxication and they will be guilty, even if the intoxication impaired their ability in some way or made them less inhibited. And this is what the expression drunken intent is still intent means. You can be drunk, but if you still intend to do something, then that is still intention. And this is the case whether the intoxication is voluntary, as in the case of Sheehan and Moore, or involuntary, as in the case of Kingston. So first, if we think about Sheehan and Moore, where the defendant set light to a homeless man, and they were charged with murder and unlawful act manslaughter, which shows that you can be charged with 2 offences, and what you'll be convicted of depends on what can be proved in relation to your intention. So the intention to kill or cause really serious harm, malice aforethought for murder, couldn't be proved. So they were convicted of unlawful act manslaughter. So that is a voluntary intoxication case where the defendants were so intoxicated that they couldn't form the mens rea, but they were then convicted of the lesser offence. By contrast, in Kingston, the defendant had been spiked, and so his intoxication was involuntary. However, the evidence showed that he could still form the intention to commit the sexual assault, and so he was convicted and unable to use the defence. So this shows that the first thing you have to think about is whether the defendant is so intoxicated that they cannot form MR, because this must be shown before you go on to consider the other elements. Also worth mentioning here, prior intent. If you become deliberately intoxicated to give yourself Dutch courage, then even if you are so intoxicated that you can't form the MR, you will be found to have formed the intention before the crime was committed, and that's Attorney General and Gallagher. So we're going to look for clues in the scenario as to whether we're going to use intoxication. That should be relatively straightforward. You're looking for someone who's been drinking all day or taking drugs, whether they're illegal drugs, prescription drugs, or even supplements, or someone whose drink has been spiked. And then you're looking at whether they are so intoxicated that they can't form the mens rea. So factors you might be looking for here might be the quantity that they've drunk, the period over which they've drunk it, the fact they can't remember anything, they're staggering about, or they have little control. All of those might point to someone who can't form MR. But by contrast, if they seem to be acting in a more controlled way, acting in a premeditated way, perhaps taking a weapon with them, then that might show that they can form MR. So you need to try and pick out some factors from the scenario that might point one way or the other. And even if you're arguing that they can form the mens rea and so they don't have a defence, you need to then go on and consider the other elements. So let's have a look at a defendant who can't form the MR. There are going to be two potential questions. And the first is, was the defendant voluntarily intoxicated? And if the answer to that is no, and you're looking at involuntary intoxication, then they may have a defence. The defendant might have a defence if they can't form the MR and they weren't reckless in becoming intoxicated. And we're going to come back and look at involuntary intoxication in a bit more detail in a moment. If they are voluntarily intoxicated, the question is, was the crime one of specific or basic intent? So if it is a specific intent crime, the defendant can't form the MR, then the defendant will have a defence to a specific intent crime, but could still be guilty of a lesser basic intent crime. And we'll consider Lippmann and Brown and Stratton in a moment. If the offence is a basic intent crime, then the defendant will be reckless and they will not have a defence. So let's have a look at the difference between specific and basic intent crimes in the AQA specification and how the rule will operate. So specific intent is a crime for which the MR is intention. So in AQA, that is murder, section 18, theft and robbery. So in terms of Lippmann, this was the case where the defendant was on an LSD trip and believed he was being attacked by snakes and woke in the morning to find that he had killed his girlfriend. He was charged with murder and unlawful act manslaughter, charged in the alternative, and he was found to have a defence to murder as he was so intoxicated he could not form mens rea, and murder is a specific intent crime, and so he was convicted of unlawful act manslaughter. Similarly, in Brown and Stratton, the fallback offence is section 20. So they were so intoxicated they couldn't form the MR for section 18. They didn't intend to cause really serious harm. They were voluntarily intoxicated. So it depended on whether the crime was of specific or basic intent. Section 18 is specific, so they could not be convicted of that, but they could be convicted of section 20. Note there that for theft and robbery, there is no fallback offence, and so you would have a defence and it couldn't be dropped down to a lower offence. So basic intent crimes are crimes where recklessness is available as part of the mens rea. So, for example, in AQA, it's assault, battery, ABH, section 20, and involuntary manslaughter, which is both unlawful act manslaughter and gross negligence manslaughter. And here, the really important case, and the key case really, if you only mention one case in an intoxication answer, you should mention Majewski, is that becoming intoxicated is a reckless cause of conduct. So the mens rea of a basic intent crime will be satisfied. So in that case, Mr. Majewski was charged with ABH and assault on a police officer, and they are both crimes of basic intent because they include recklessness in the MR, and he had taken drink and drugs, and he was found to be voluntarily intoxicated, charged with crimes of basic intent, so he couldn't use them because he was reckless in getting intoxicated, and so he had the MR of those crimes. So lastly, we're just going to move on to what constitutes involuntary intoxication. So we've got the normal thing you might think of, the having your drink spiked. You didn't know you were taking alcohol or a drug and you couldn't form the MR, and then you will have a defence for both specific and basic intent crimes. So things to look out for are your drink being spiked, but remember in Kingston, although he'd been spiked, he could still form MR, so he couldn't use the defence. But also these situations, taking prescription drugs and taking drugs that normally have a soporific effect. So in Bailey, the prescription drug that the defendant had taken was insulin, and he was potentially not allowed to use the defence. You wouldn't be allowed to use the defence, even if the insulin has affected you, if you didn't eat afterwards and you knew that not eating was going to put you into that state, because you've been reckless. So if you've been reckless, then you won't be able to say you're involuntarily intoxicated. By contrast, in Hardy, he had taken Valium, which is a drug known to have a soporific effect to calm you down, but it had an unexpected effect in that case, and he was allowed to use the defence as he hadn't been reckless, and taking the Valium did prevent him from appreciating the risks of his actions. So that wouldn't apply if he'd taken a dangerous drug, or if he'd done it before and he knew he reacted badly to Valium. But in those particular facts, he hadn't been reckless. So you're looking out there for recklessness, because that might make intoxication voluntary. Last thing to note on involuntary intoxication, that not knowing the strength of drink or drugs doesn't make the intoxication involuntary. And that's the case of Alan. That was about homemade wine, and the defendant said they didn't know the strength of it. But that doesn't mean that you are involuntarily intoxicated. It's still voluntary intoxication. So let's have a look at scenario question that brings in intoxication as a defence. So in this scenario, which came from the 2020 paper, you had to consider the criminal liability of Frank in connection with the £200 and the death of George. So once you've read the scenario and the question carefully, have a think about how you would use intoxication as a defence in this question. And then when you've had a think about that, let's have a look at the answer, or what I would suggest you would put in. So points to consider, asks about the death of George, but Frank here doesn't intend to kill George or to cause him serious harm. So there is no malice aforethought, so he doesn't have the mens rea for murder. So the relevant offence you'll be considering is unlawful act manslaughter. He also becomes intoxicated after the robbery, so it's not a defence to the robbery part of the question. So when you are doing the question, you would have gone through all the elements of unlawful act manslaughter, and here it would be based on an assault. So when you're talking about the mens rea of an assault, did Frank intend, or was he reckless as to causing George to apprehend immediate unlawful force? You could mention the intoxication there and say subject to the defence of intoxication I'll discuss below. Doesn't matter if you don't do that, but you can do that. And then after you finish discussing the offence of unlawful act manslaughter, then you would consider intoxication. So in relation to the intoxication, you would identify the defence as he's under the influence of alcohol. He's drunk a large amount of alcohol in a pub. You would consider whether he could form the mens rea. He had drunk a large amount, so maybe he was so intoxicated that he couldn't form the mens rea, but he was annoyed he'd been recognised and he had enough control to throw his beer at George. So arguably, it's not like Sheehan and Moore, where no mens rea was formed, and potentially more like Kingston, where mens rea was formed, but you would need to speculate. Whatever you decide, if you're going to use the defence, you're assuming he couldn't form MR, that he was so intoxicated he couldn't form MR. Then the next question is, was his intoxication voluntary or involuntary? And here it's voluntary, as he was drinking in the pub. And because it's voluntary, the last question is whether the crime is one of specific or basic intent. So the defence will depend on that. And as unlawful act manslaughter is a basic intent offence, as it includes recklessness in the MR, using Majewski, he's been reckless and becoming intoxicated, and so he won't be able to use the defence to any charge of unlawful act manslaughter. So I hope that that's been a useful summary of the elements and how you would apply them in a scenario. This is just a recap of the basic structure. The three elements to consider: can you form the necessary MR? Is the intoxication voluntary or involuntary? And is the offence specific or basic? And the effect will depend on those answers. So I hope that's been useful. Thanks very much.